So the Supreme Court will hear their next major Second Amendment case, and it's coming up this November. So let's break down what is going on. But real quick before we jump into this video, if you think the Supreme Court needs to strike down more gun control laws, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is TacPack. TacPack is a subscription-based box that delivers tactical and EDC gear to your door every single month. Every single month, TacPack's team puts together an amazing box. For example, this Plus box, which I really like. I got a bolt carrier group for an AR-15, a radiant charging handle, which is awesome, one of the best ones on the market, a Reptilia pistol grip, and then also a pistol case, and a bunch of other items. You get like shirts, stickers, a lot of things. So right now, TacPack is doing something really cool for my viewers. If you use the code ARMED, you will receive an additional free box worth at least $60 with your subscription box. So I will leave a link down below to TacPack. It's going to be in the pinned comment in the description section. And again, make sure you use that code ARMED to get that free additional box. As I mentioned in the intro, in this video, we're going to be discussing an important Second Amendment case, which was granted review by the Supreme Court and is now set for oral arguments this November. That means that the Supreme Court will hear and rule on a new Second Amendment case before the end of their next term. This case is called U.S. v. Rahimi. In this case, the government was actually the ones who sought Supreme Court review because the Fifth Circuit recently ruled that the federal prohibition on gun possession for people subject to a domestic violence restraining order is in fact unconstitutional under the Supreme Court's recent decision in Bruen. The Supreme Court has now granted review to this case and will decide if they want to strike down this federal prohibition on the possession of firearms by anyone with a domestic violence restraining order because it violates the Second Amendment. This decision also has huge implications for other cases because we will get further clarification on how the Bruen analysis should be applied going forward. This could have positive impacts, but it could also have negative impacts because the anti-gun side hopes to use this case to limit the decision in Bruen. Now, the facts around this case are not great, and I want to state from the outset that Mr. Rahimi does not seem like he's a good person. There are plenty of other things that Mr. Rahimi did that should have resulted in a conviction, but this specific case has to do with his civil protection order that he was subject to and him being found in possession of a firearm. So between December of 2020 and January of 2021, Mr. Rahimi was involved in 5 shootings in and around the Arlington, Texas area. On December 1st, after selling narcotics to an individual, he fired multiple shots in that individual's residence. And then the following day, Mr. Rahimi was also in a car accident where he exited the vehicle, shot at the other driver, left the scene, fled, came back, and then the allegation in the police report says that once again he shot at that vehicle. Then in January, Mr. Rahimi allegedly fired multiple shots when his friend's credit card was declined at a Whataburger restaurant. And then the Arlington Police Department identified that that individual, the suspect, may be Mr. Rahimi, and they served a search warrant and they searched the home that he allegedly was residing at. And in that residence, they found, I believe, a pistol and a rifle. Now, where this case all arose out of was the fact that Mr. Rahimi was already subject to a civil protective order, which was entered in against him on February 5th of 2020. So he was not supposed to be in possession of any firearms. And he was subject to that civil protective order because he allegedly had assaulted his ex-girlfriend. That protective order that he was subject to restrained him from harassing, stalking, or threatening his ex-girlfriend and their child, and it also expressly prohibited Mr. Rahimi from being in possession of any firearms. And as a result of those two situations combined, a federal grand jury indicted Mr. Rahimi of possessing a firearm while under a domestic violence restraining order in violation of federal law 18 U.S.C. section 922G8. Now, early in this case, Mr. Rahimi brought a challenge against that federal law and claimed that it was unconstitutional because it violated the Second Amendment. However, he lost that argument since prior Fifth Circuit precedent found under the interest balancing approach that that federal law was constitutional. But then the Supreme Court issued a 6-3 decision in Bruen, authored by Thomas, and it reaffirmed that text as informed by history and tradition is the proper analysis, and that interest balancing should not be used. Then what happened is the Fifth Circuit panel withdrew their prior opinion that they used the interest balancing approach, and they reanalyzed the Rahimi case using that Bruen precedent. And using Bruen, they found that the prohibition on the possession of firearms and ammunition by someone subject to a domestic violence restraining order under that federal law was in fact a violation of the Second Amendment. Now, after the Fifth Circuit panel found that this section of federal law was unconstitutional, obviously that decision did not sit well with the government, so they decided to essentially seek a writ of certiorari to the Supreme Court. What was interesting is they bypassed the Fifth Circuit en banc panel and instead went directly to the Supreme Court. And then at the end of the Supreme Court's last term, during some cleanup orders, we got news that the Supreme Court did in fact grant review to this case. This is significant not just for the 922G8 law in question of this whole case and decision, but this decision will have broader implications for all other 2A cases going forward. The decision of the court will have to apply the Bruen analysis against 922G8. That means we will get further language on when gun control laws like this one meets the text and history standard and when they do not. Also, this case and this decision will center around who are the people as stated in the text of the Second Amendment, which is significant. Now, the Supreme Court has set oral arguments in the Rahimi case, and that will take place on November 7th. So really soon, just next month, about a month away, the Supreme Court will hear arguments on the constitutionality of 922G8, and they will see what impacts Bruen has on these types of federal laws. Now, Rahimi's attorneys also submitted their brief to the Supreme Court, arguing why the Supreme Court should rule in their favor. In their brief, they argue that because it faithfully applied the holdings and reasoning in Heller and Bruen, the government does not ask this court to overrule or limit Heller or Bruen, and Bruen makes this an easy case. 5 features of 18 U.S.C. section 922G8 conspire to make the statute facially unconstitutional under the Second Amendment. First, the law is a total ban on the possession of any type of firearm or ammunition, even in the home. Second, the ban is enforced with severe criminal penalties of up to 10 or 15 years in federal prison. Third, the ban applies to the United States citizens who retain all their political and civic rights. Fourth, the ban is not triggered by conviction of an infamous crime. It arises automatically and unavoidably from a civil state court order, often after a one-sided proceeding, regardless of whether the order itself addresses firearms. Fifth, section 922G8 is a federal nationwide ban. Whatever the founding generation believed about the state and local legislators' power to restrict firearms ownership, they would have resisted a federal law purporting to say which citizens could and which citizens could not keep firearms. They go on to state that the government attacks the outcome below, but refuses to engage in Bruen's process. The Second Amendment protects a U.S. citizen's right to keep firearms within the home for self-defense and defense of others. Section 922G8 severely punishes any exercise of that right. Because there is no historical tradition of any similar restriction, the law is unconstitutional on its face. Now, in this brief, Mr. Rahimi points out that the criminal conviction used by the government to make this situation seem more extreme and severe really isn't at issue in this case at all. Instead, the only question they argue that is in question is the situation and the process that made him subject to that civil protection order. He argues that he did not get representation or a hearing, and that the procedures are inherently biased in favor of the state against someone like him in his situation. He also states that the police found that the firearms were in his room, but at the time of the warrant being served, Mr. Rahimi had not lived at that home. He had not even been living in the same city, so he argues potentially that those weren't his firearms, and he wasn't living in that home. So how could he be subject to being in possession of those firearms when he wasn't even staying there? So in this brief, Mr. Rahimi is trying to isolate this case from some of the other facts that were presented to the Supreme Court, and the hope is to just keep the Supreme Court focused on the civil protection order and that specific facts and situations surrounding the civil protection order, and not all of the other bad acts that potentially he had engaged in. They go on to argue that the government cannot show under Bruen how this federal law is consistent with the text, history, and tradition of our nation. They argue that despite casting an incredibly broad net, the government has yet to find even a single American jurisdiction that adopted a similar ban while the founding generation walked the earth. The government cites no laws punishing members of the American political community for possessing firearms in their homes based on a dangerousness, irresponsibility, crime prevention, violent history, or inclination, or any other character trait or legislative goal. Put simply, they state, Section 922G8 is an outlier that our ancestors would have never accepted. So this is going to be a critical and very interesting landmark case going forward. Again, there's going to be oral arguments in this case on November 7th. There's probably going to be some live audio. Maybe we'll live stream that. Let me know down in the comment section if maybe you guys would be interested in a live stream, so we can definitely do that. But let me know in the comment section if you'd be interested. Also, if you like this video and you like to support the channel, one of the best ways to do that, of course, is to like, comment, subscribe. One of the free ways to support this channel is to subscribe to the channel. YouTube is unsubscribing people, so always make sure you're checking to make sure you're still subscribed to the channel. A lot of people say, hey, I've been unsubscribed. That's YouTube doing that. And then also just make sure you have the notification bell on. Make sure all notifications on, because that ensures that you will actually get this information and maybe just helps to prevent some of that weirdness that goes on. But as always, thank you guys so much for all of your support. Don't forget to like and subscribe, And never forget, the station was built by armed scholars, and the station will be maintained by armed scholars.